Surtout avec le froid qu'il fait, avec le temps qu'il fait, de vous voir tous ici ce matin, c'est vraiment un bel exemple des défis canadiens auxquels on fait face ensemble. Whatever the season, however, or whatever the weather, our Big Thinking series is there to bring research from the social sciences and the humanities closer to you, the people who can use it, must use it, to inform decisions about policies that affect the lives of Canadians. And I'd like to thank our partner in this big lecture series over the course of the season, the Social Sciences and Humanities Research Council, for their continued support and also their continued engagement in our projects. Thank you very much. I'd also like to thank James Raziq, our parliamentary sponsor, for making this event possible as well. Aujourd'hui, nous sommes particulièrement fiers d'avoir comme partenaire la Fondation Pierre Elliott Trudeau. Our partner for this event, the Pierre Elliott Trudeau Foundation, grants doctoral scholarships, awards fellowships, appoints mentors, and holds public events encouraging critical reflection and action in human rights and dignity, responsible citizenship, Canada's role in the world, and our people and their natural environment. So we're very happy to be a partner with the Trudeau Foundation on this particular event with Kent Roach. Et j'aimerais maintenant inviter le président de la Fondation, Maurice Rosenberg, who most of you need no introduction of, since he was Deputy Minister, former Deputy Minister of External Affairs, and also of Health Canada, and he will introduce today's speaker. Maurice.
Merci beaucoup, Antonia, et bienvenue à tout le monde. I salute your courage for having come out here on a cold morning and brave not only the weather, but the increased security on the Hill. This is my first time being back in a while with no parliamentary pass, and it's quite a different experience getting onto the Hill when you're just a citizen. So I just want to situate this in terms of the work of the Trudeau Foundation. Every year, the Pierre Elliott Trudeau Foundation selects up to 5 fellows who have enhanced knowledge and advanced society through leading-edge research, creative work, and a commitment to societal debates on major issues of public policy. And the Foundation's support enables its fellows to devote themselves more freely to critical thinking and innovative approaches in their field. In collaboration with Canadian universities and other institutions, the Foundation a few years ago launched the Trudeau Lecture Series. The lectures are an annual series of talks delivered by Trudeau Fellows in which the Fellows highlight their ideas, their research, and their role as public intellectuals. C'est un plaisir pour moi ce matin, en collaboration avec la Fédération des sciences humaines, de vous présenter le conférencier de ce matin, Kent Roach. Kent Roach est un professeur de droit à l'Université de Toronto, où il est titulaire de chair Prichard-Wilson de droit et de politique publique. Il est diplômé des universités de Toronto et Yale et a été auxiliaire juridique de feu la juge Bertha Wilson à la Cour suprême du Canada. Monsieur Roach est rédacteur en chef de la revue Criminal Law Quarterly depuis 1998 et membre de la Société royale du Canada depuis 2002. Kent is the author of 12 books, including a number that have either won prizes. Constitutional Remedies in Canada was the winner of the 1997 Owen Prize, and a number of others that have been shortlisted for other prestigious awards, including the Donner Prize. His books are on criminal law and on the Canadian Charter of Rights and Freedoms are widely used in Canadian law schools and by practitioners. Professor Roach has frequently acted as pro bono counsel for interveners in the Supreme Court of Canada, especially in cases involving judicial remedies, national security, and Aboriginal people and the criminal justice system. He's worked with a number of inquiries, including the Ipperwash, Arar inquiries, the Truth and Reconciliation Commissions, and has served as Research Director for the Gouge Inquiry into Forensic Pathology and the Inquiry into the Air India bombing. Internationally, he's provided advice on Indonesia's 2002 terrorism law and Tunisia's new constitution. And his current research includes comparative examinations of constitutional remedies, counterterrorism, and wrongful convictions. So the lecture this morning is titled Judicial Activism and the Role of the Courts in Providing Remedies. So the context for this is that courts throughout the world are becoming more active in providing remedies for violations of rights. For example, in the United Kingdom, courts are reinterpreting and even rewriting laws to ensure compliance with the European Convention on Human Rights. You can see this in countries in Africa, in South Africa and Kenya, where courts are struggling with the challenges to provide remedies for a broad range of socioeconomic rights. And you will have read over the past couple of years that there's been an awful lot of litigation in the United States around conditions in prison, people considering overcrowding in prisons and the conditions there being kind of cruel and unusual punishment. And judges have ordered the release of prisoners as a way of dealing with these unconstitutional conditions. And here at home, you've got decisions like the Shirley decision a few years ago on health care and recent cases in areas like drug laws, prostitution, and assisted suicide that would all suggest that remedial activism is alive and well here as well. So Kent's lecture will situate the experience of Canadian courts in ordering constitutional remedies within the experience of other democracies. And he'll examine the strengths and weaknesses of courts vis-a-vis the legislature and the executive and the effect of remedies on the separation of powers. Donc avec ça, c'est un plaisir pour moi de vous présenter le conférencier de ce matin, Kent Roach.
Je veux remercier tous de votre présence ce matin, and that's why we're going to do this in English. I would like to thank the Federation for the Humanities and Social Sciences for all the work that went into organizing this event, and indeed my entire day on Parliament Hill. For an academic with a career-long passion for public policy, this is a real treat. I would like to thank Morris for his generous introduction and everyone associated with the Trudeau Foundation for their generous support of my work and for providing such a welcoming and stimulating intellectual home. The very word judicial activism is controversial, and I've written about it before. But today I want to focus on some of its more practical and less ideological aspects. Remedies implicate separations of powers. What are the appropriate roles of courts, executive, and legislature? And I hope that the approach to remedies that I propose here today, and who knows, maybe the Supreme Court will take in tomorrow's decision, will make room for the distinct role and expertise of all three levels of government. As Chief Justice McLaughlin observed in 2010, remedies tend to be neglected. They get, she says, whatever space and energy is left over after the big principles involving rights have been decided. And again, I find this in today's commentary about the upcoming Carter decision. Everyone is focusing, will the Supreme Court change their mind? Will rights be violated? That's obviously very important, but so too will be the remedial details should the court decide that the law is unconstitutional tomorrow. The Chief Justice, a former remedies teacher herself, noted that remedies have virtues. They are, she says, practical and down to earth. They allow us to mend our wounds and carry on as individuals and as a society. So remedies are important, and I'm going to start talking about actually a very traditional remedy. My sense is that with respect to damages, we may be losing sight of the importance of this traditional remedy, and we actually need to reinvigorate it. Probably most people here are familiar with Chief Justice Holt's statement, "It is a vain thing to imagine a right without a remedy." He actually made that in dissent, but eventually the House of Lords upheld an award for £5 for the loss of the voting rights in the Ashby and White case of 1703. We fast forward that in the UK, where the Hearst decision, a very controversial decision of the European Court of Human Rights, held that the total ban on prisoner voting in the UK was contrary to the European Convention. Was not backed up, however, by a remedy, and most recently in Firth, the European Court of Human Rights in 2014 found that damages were not necessary for the over 2,500 prisoners who had applied for a remedy because they continue to be denied their right to vote since the 2015 decision. Now, given that this is the Trudeau lecture, I wanted to start with also a little bit of Canadian history, and that is the Ron Corelli and Duplessis case. And you see this old picture that reflects the amounts that Mr. Ron Corelli was awarded. In some ways, that decision, which is celebrated today as an affirmation of the rule of law, demonstrated a certain amount of judicial activism. The trial judge had awarded Mr. Ron Corelli $8,000. You'll remember that his liquor license was taken away by Premier Duplessis because Mr. Ron Corelli was posting bail for Jehovah's Witnesses. And the Supreme Court raised it actually to $46,000 with interest going back to 1946 when the trial was held. In today's dollars, that would be $370,000. Indeed, some people saw this as an overly creative and generous approach to remedies. But I think that Mr. Trudeau's experience with the role that the court, and particularly the Supreme Court of Canada, played in the 1950s may help to explain why, in Section 24(1) of the Charter, we have entrenched the role of the courts in providing appropriate and just remedies. Ron Corelli is the most famous case from the 1950s, but there are other cases. And in some ways, if you look at $2,500, it looks modest, more or less what we're awarding today. But remember, in the 1950s, the average income was $4,000 and homes cost $11,000. So this brings us to the Cameron Ward case. The Ward case, decided in 2010, provides a principal basis for awarding charter damages under Section 24(1) of the Charter. The court recognized a broad range of remedial principles of compensation, vindication, and deterrence. Nevertheless, the $5,000 awarded to Mr. Ward for an unconstitutional strip search ensures that only the economically irrational will bring such claims. This means that damages must either be catastrophic, as in the Mayor Arar case and other torture cases, or aggregated into class actions, as is happening with the G20. But even in the G20 claim for class action damages, the cost of even getting the class action certified amounted to $180,000. The plaintiff's counsel actually asked for $750,000. So we're in an environment where unless you have catastrophic damages or unless you're able to aggregate them in a class action, it would be economically insane to go to court and to ask for a damage remedy. Now, despite these very real financial barriers on litigation, I recognize that some fear that we are becoming a more litigious nation like the United States. The American Congress, in bipartisan 1996 legislation, responded with litigation limiting damages and other remedies that prisoners could obtain. Now, you might say, well, that's the Americans. We'll never have that issue. But indeed, the New Zealand legislature in 2005 passed very similar legislation that was a pushback and a response to courts awarding damages to prisoners whose rights were violated under the New Zealand Bill of Rights. And so one question that may arise in the future is, would such legislation be permissible in Canada? This takes us to the story of Nicky McArthur, a violent bank robber and repeat escapee. Bad guy. In 2010, the Supreme Court held that he had a right grounded in Section 24(1) of the Charter to sue for damages in Superior Court for being detained in solitary for 4.5 out of 5 years. It rejected the government's argument that McArthur was doing an end run around the prison disciplinary process. I agree with that case. I think it's a good thing that our courts have a constitutionally guaranteed remedial jurisdiction. Courts listen to the individual, and when their claims are substantiated, they provide remedies. That's not newfangled judicial activism. That's old-fashioned legality. As the Mayor Arar case confirms, Canada takes a different approach to the U.S. with respect to judicial remedies, and I think we should be proud of that approach. In the U.S., Mr. Arar's lawsuit was preemptively shut down on the basis that a damage award might harm national security. The courts have an important institutional commitment to hear rights claims from even the most unpopular. For example, a court held that Abusian Abdul Raziq's charter rights were violated, and it retained jurisdiction until he returned from Sudan. Subsequently, Mr. Abdul Raziq was delisted from the UN list of people associated with al-Qaeda, and he is seeking damages in court. Again, some may see this as judicial activism, but this is a traditional judicial function. We also saw a similar approach with respect to the retention of jurisdiction in an interesting aftermath of the Supreme Court's decision involving Omar Khadr. The same judge who had retained jurisdiction in the Abdul Raziq case retained jurisdiction in this case to order an effective remedy after both sides had consulted about an appropriate response, what should be done in response to the Supreme Court's declaration that Canadian officials had violated Mr. Khadr's rights. Remember, at this time, Mr. Khadr was still in Guantanamo. And Justice Zinn said, look, if there's a declaration, that's a relatively soft remedy, there should be consultation between the affected people about how governments implement a declaration. And he retained jurisdiction to facilitate that consultation process. As you know, that was extremely controversial. The government was able to have the appeal, have the judgment stayed during appeal, and Chief Justice Blais, in his stay decision, indicated that this innovative remedy should be stayed, in part because it interfered with the executive's national security responsibilities. So there are controversial issues. But I would say that a court's retention of jurisdiction, again, is not a new invention of a new style of judicial activism. William Blackstone, in the 18th century, talked about the court's equitable powers and how they retain jurisdiction. And he writes, very seldom does it happen that the first decree will be final. 100 little facts must be cleared up. And of course, the modern age of retention of jurisdiction owes its case to Brown versus Board of Education. And again, I use Brown versus Board of Education with my students as a lesson that if you're going to make innovative rights claims, you better figure out a remedial strategy for the courts. It's clear from the historical record that the Supreme Court, even though its remedial strategy, which was all deliberate speed, remand back to the lower courts, even though that was decided in 1955, the Supreme Court actually was grappling with the issue of how it would remedy school desegregation in 1953 before the court ever decided. So the court was not going to decide to recognize that school desegregation was unconstitutional until it had a remedial strategy. People disagree about that remedial strategy. Some say it's too strong, some say it's too weak. But remedies are important, and they should be much more of a central focus in our thinking. One of the most fiercely decided Supreme Court of Canada decisions involved an issue of whether a trial judge could retain jurisdiction to hear progress reports from the government in open court about the construction of French language schools in 5 different regions of Nova Scotia. That's why I put this map of Nova Scotia up. The case is called Doucet-Boudreau, decided in 2003. 5 judges said the trial judge was right. They recognized the complexities of the situation and the fact that judges should not order the impossible, but they were also sensitive and said judge could retain jurisdiction in order to ensure constitutional compliance. This was 2003. Nova Scotia had not complied with minority language education rights, and in particular, the need for minority language facilities. 4 judges said the trial judge was wrong. 4 judges said he violated the separation of powers, and the only thing the trial judge could do in their view, and this in some ways is a potential form of judicial activism, is to order a clear and enforceable order, and if the government did not comply with that, to enforce it by contempt. The majority stressed a fair process. The majority said the trial judge's order, which was that the government make its best efforts to construct the school, was actually moderate. The minority stressed that any remedy should be clear and enforceable, something that I fear actually will be impossible given the complexities of public institutions. So I actually think the majority took the right approach. And again, although some may see this as judicial activism, I think it is quite critical that the trial judge there said whatever is going to happen is done in open court. Right? So, I mean, judges should not just phone people up and say, well, how's compliance going? Right? They should do it in a procedurally appropriate way. Now, the Supreme Court has not overruled the 2003 Doucet-Boudreau case, but late last year, it sounded a lot like the minority in holding that a trial judge had erred in retaining jurisdiction over Air Canada on a bilingualism issue. Now, again, I'm not saying the merits of that case are wrong, but this formula that remedies must be clear and enforceable, I think puts judges in a catch-22 position. Judges will rightly not want to execute the exact details. They will know that they are not experts. They will know that things can change. But the Supreme Court seems to be linking retention of jurisdiction with the issue of clarity and enforceability. Where it seems to me it's much better, as in the Manitoba language reference, for the Supreme Court to say we are going to retain jurisdiction because issues may arise, unexpected issues may arise, and the parties may want to come back to us for clarification. Not in a lunchtime conversation, but in a procedurally fair way. So this raises the question of whether Canadian courts would ever retain jurisdiction over an unconstitutional and unfit prison. As Morris recognized, the American courts have done so, and indeed, in 2011, the United States Supreme Court, in another 5-4 decision, affirmed an order that California must significantly reduce its prison population because of its inability to provide constitutionally adequate health care, physical and mental health care, to prisoners. One objection, and it's a serious one, is that courts are unsuited for resolving multifaceted or polycentric problems. The California prison case was polycentric. You can't resolve health care issues, at least in Californian prisons, without dealing with issues of solitary confinement, which affect the prisoner's mental health. And you can't deal with issues of solitary confinement without dealing with discipline and overcrowding. So essentially, this case soon unraveled to one that is not simply about prisons, but is about all aspects of the California criminal justice system. I suspect that Canadian courts would be very reluctant to take such an approach. One reason may be that our problems are not as extreme as California. This is a picture of the overcrowded California prison. This was a real problem. But there are problems in Canadian prisons. This is the Baffin Correctional Centre. The correctional investigator who's here has done a report on the Baffin Correctional Centre. May not essentially be California, but it certainly is not perfect. This is Ashley Smith. So we have institutions and prisons raise polycentric problems, but are there polycentric solutions? Can judges, even though they may not be able to see all aspects of a problem, can they make a constructive contribution to resolving issues of constitutional compliancy? Not all by themselves, right? So the stereotype is a judge runs a prison. My study and other empirical studies show that it's not nearly that simple. What judges can do is articulate general standards, work with the parties. If they need more information, they can get more information from the affected people. And I think that retention of jurisdiction is an important aspect of this, even if the judge is not saying, clear and enforceable. It may be premature to have clear and unenforceable. And the retention of jurisdiction allows the judge to avoid micromanaging the institution, but it also avoids the problem in the Little Sisters case where there was a declaration that Customs had profiled and discriminatorily targeted a gay and lesbian bookstore, but there was emerging problems. And Little Sisters had to go to court again, and then we come back to access to justice issues. They never were able to go on. Now I'm going to end, I think, on a more controversial note, which hopefully will dispel, or perhaps not, ideas that this is kind of an ideological approach. Because really, one of the reasons why I'm focusing on remedies is I think that the debate about judicial activism has become way, way too polarized, not evidence-based enough. And I want to talk about the Shirley healthcare case, which was very controversial. Some believed that Medicare was in jeopardy. But as Chief Justice McLaughlin reminded us, don't forget about the remedy. And the remedy in Shirley, very few people talk about. The court, yes, struck down Quebec's restriction on private health insurance, but after the judgment was rendered on a motion from Quebec, it suspended the declaration for 1 year. Suspended declarations of invalidity, which may happen tomorrow in the Carter case, I think are an interesting Canadian invention, right? Canada has really pioneered here. South African Constitution, Section 172, actually has picked up the Canadian practice and put it right into the South African Constitution. The suspended declaration in Shirley allowed Quebec to respond, yes, in a dialogic way, but in a way that expanded the conversation. What did Quebec do? Quebec allowed private insurance, but in a regulated way. But at the same time, it tried to respond to the wait time problem that motivated the court's decision. Tomorrow, the Supreme Court will hand down the Carter case. Alas, I don't have an advanced copy. But if the court strikes the law down, I hope that it will confirm a two-track remedial strategy taken by the trial judge. The first systemic track is to remand the polycentric problems of future regulation of assisted dying to Parliament. Parliament may not welcome this, but an immediate declaration of invalidity may not be responsible. Another alternative that the BC Court of Appeal suggested is Parliament might not be able to handle a suspended declaration of invalidity, so you just have constitutional exemptions on a case-by-case basis. I actually think that would be a more illegitimate decision, because it would take away from Parliament the ability to consult about the details, and not just the details, the policy about how how the response should be. So the first track of remedies is being deferential either to the legislature or the executive to give them an opportunity to fix the problem. Not to say we blindly defer to them, but to say, you guys, you get a shot at trying to fix this. But the second track is also really important, and that is that the courts must exercise their traditional function of giving effective remedies to the individual. Now, alas, in the Carter case, both cases are moot, as indeed, in a way, they were in the Shirley case. But I think that we should also expect courts to provide effective individual remedies. And so one of my concerns with the refugee healthcare case is the trial judge appropriately deferred on a systemic basis, but she only gave 4 months for the government to respond. I don't think 4 months is nearly enough time. I think she probably should have given the government 12 months. But I think she gave 4 months because she also made, respectfully, what I think is a mistake of not giving an immediate remedy to one of the individual applicants, in this case, Mr. Hanif Ayubi from Afghanistan. He needed insulin to live, and she delayed that individual remedy for 4 months. So I think that we will stay true to the separation of powers if we think about these two different tracks. A systemic track where the court defers to the legislature and the executive, gives them an opportunity to fix the problem, but also doesn't allow them to ignore the problem, and an individual track where the court provides an effective remedy. And although some may see that as judicial activism, I see that as the court publicizing and responding to injustice in a way that probably the legislature and the executive are just not structured to see. And so you do have this back and forth. So you may not agree with this approach. You may not agree with me that this reconciles the issues of separation of powers, but I hope you will agree with me that the remedies are an important and interesting subject despite being neglected. So I'm happy to take any questions. And I'm also happy to unsecure.
Don't go away. So I just want to thank Kent very much. So just whenever I hear you speak, and especially today on this topic, this is the real way that social science actually engages with important matters in policy making. So I just want to thank Kent again for that brilliant tour de force. It was very, very interesting and very controversial. I have a lot of things to say, but I'm not going to say them because I know that we have questions from the audience. Since we're in the House of Commons, comme on est au Parlement, I'm going to impose House of Commons Parliament's rules, which is that you get 30 seconds, I think, to state your case or ask your question. I'm not sure if you only get 30 seconds to respond, but we'll let Kent take all the time he needs to respond. But please, free. The mics are in the center of the room. S'il vous plaît, vous pouvez poser votre question en anglais ou en français. Je vais traduire s'il y a besoin. Courte, et Kent est là pour répondre. Et aussi, si vous pouvez vous présenter. Just tell us who you are. Thanks.
Lisa Kerr, 2012 Trudeau Scholar. So, Kent, one of the factors in the U.S. that we know now is that prison administrators often welcomed judicial intervention. It was one of the few ways that they could actually get the resources that they needed and to improve conditions in the way they wanted. In California, the problem was the state legislature refused to allocate the resources that the prison knew it needed in order to stop an unnecessary death a week. So what I'm wondering is, in the Canadian environment, we know there are certain chronicle political failures on corrections. Is that realism about how judicial intervention is just mandatory, is necessary, may even be welcomed by prison administrators and line officers? Is that a legal argument? How do you make it?
Yeah, well, I mean, you know, my worry is, as Doucet Boudreau becomes more and more of a kind of political hot potato, we don't have the Canadian experience about institutions. And that's why I think the current litigation on solitary is not asking for a 24-1 remedy. It's, I think, quite shrewdly asking for a legislative remedy. And that may work. But I do wonder that, are we going to get into a position where judges simply have a kind of hands-off about the conditions of individual prisons, whether it's Baffin Corrections, whether it's Toronto West, which was opened without any health care. And hopefully we won't have to go the American route, but I worry about an environment where judges simply say there's nothing that we can do about it.
Bonjour, Denis Blanchette, député néo-démocrate de l'Ouébert, Ville de Québec. Merci pour la présentation. Quand je regarde l'évolution de ce qui se passe présentement dans la législation, le recours à la Cour suprême, je crois que ce que j'observe, c'est qu'il y a de plus en plus de lois qui sont contestées et celle que le gouvernement vient de déposer, entre autres C-51, risque également de susciter beaucoup de débats, si ce n'est pas de se retrouver, comme beaucoup d'autres encore, devant les tribunaux. Et évidemment, va nécessiter des compensations à un moment donné parce que on commence à jouer un peu avec les libertés civiles. Donc, à ce moment-là, les droits risquent d'être attaqués et donc des compensations exigées. Alors, ma question pour vous, elle est simple. C'est dans le contexte d'aujourd'hui, où est-ce qu'on a, où on est obligé d'adapter le cadre législatif à de nouvelles réalités, j'aimerais, d'une part, que vous nous donniez un petit peu un aperçu de la façon que vous aimeriez que les législateurs que nous sommes adressent des problèmes comme la sécurité. Et d'autre part, quelle serait, selon vous, une approche qui permettrait de réduire les retours au Parlement de ces lois-là comme telles? Parce que trop souvent, ces dernières années, il y a des lois qui sont adoptées par la Chambre des communes et qui nous sont retournées comme telles. Alors, ce que j'aimerais, c'est avoir vos impressions sur ces sujets. Merci.
Well, merci pour votre question. I actually think that the back and forth is good, right? I mean, you know, with the prostitution bill, we had a suspended declaration of invalidity. Some of the people who brought the case are not very happy with how Parliament responded. There will be other charter challenges. I mean, this is part of the way we govern ourselves. And this, to my view, brings more debate and more democracy. So yes, I mean, a 12-month suspended declaration of invalidity puts an awful lot of stress on Parliament. But I think that it is often going to be better than an immediate declaration of invalidity, which may have unforeseen consequences. So I actually think that this is the world that we live in, and I don't think that it's necessarily a bad thing. I think that Canadians want Parliament to address the hard issues and to take a recurring look at the hard issues. And some of those hard issues are going to be raised by individual people who raise rights claims. Now, lots of rights claims are going to be denied. And, you know, one of the things that I didn't have time to talk about, and I know Antonio would ask me, what about the issue of queue jumping, right? If we have healthcare remedies, is this just going to allow those who can litigate to jump to the head of the queue? And I think that there's something to that, right? And as Canadians, right, we all are very proud of how we conduct ourselves in queues, especially at Tim Hortons, right? But all litigation is a form of queue jumping. Mr. Ron Corelli jumped the queue. There were other Jehovah's Witnesses who were harmed by Duplessis. The late Mrs. Gloria Taylor attempted to jump the queue because she wasn't the only person who wanted physician-assisted dying. So the argument from queue jumping, the argument that you will have a sympathetic plaintiff and somehow the courts will be seduced by that. Yeah, the courts may be seduced, but that's the traditional function of giving an individual remedy. And yes, I mean, queues are not perfect for allocating scarce resources. They are one way of doing it. And in Shirley, Quebec was able to reaffirm the integrity of the queue system, but only after the court paid attention to the individual facts of the case. And I think that case would have been more compelling if the facts were more compelling. So I think it's another question whether the court was right on its merits. But cases like Mr. Ayubi, I mean, we can't ignore that, right? This is a person who cannot go back to Afghanistan because he's on our restricted list, and he needs insulin. Will a remedy affect? Will it cost something? Yes. Charter rights costs. Remedies cost. Will he jump the queue? Yes. But I actually think our democracy is enriched when we debate our systemic problems in light of their effects on particular individuals. And that's why I hope in the upcoming debate on Bill C-51, we think about Mr. Arar. We think about Mr. Abdul Raziq. I'm not saying that that should determine our security policy, but we're enriched by this back and forth and dialogue where courts do what courts are good at, which is to hear individuals who feel aggrieved, and if the court concludes they're aggrieved, provide them with remedies, and we ask the legislature and the executive to be better, to exercise their functions. Anyway.
I'm Ruel Anger, and I write for Canadian Charger. It's been my observation that the Harper government has attempted to appoint judges who might be more inclined to support their social philosophy, and it's seemed to be an unsuccessful kind of effort on their part. Even the conservative, with a small c, judges that they appoint don't seem to go along with them, and I wonder if you'd comment on that.
Well, I mean, the judge who retained jurisdiction both in the Abdul Raziq and Cotter case was an appointee of this government. So I think that there's something to that, and I think that that's because judges have an institutional commitment to decide cases on the basis of the evidence before them. And so that's really all I can say about that.
My name is Sean Casey. I'm a member of Parliament for Charlottetown and the Liberal Party Justice Critic. I was interested in your comments on the suspension of invalidity and then an answer to an earlier question about the prostitution case. With the prostitution case and the declaration of the suspension, police forces across the country sort of took things into their own hands and said, well, we're just not going to enforce the law. And so we had the court saying that the laws are still valid for a year, and police forces across the country saying we're going to ignore it. Is that relevant, and should it be?
Right. No, thank you, Mr. Casey. That's a good and important question. I think that in the early jurisprudence where the Supreme Court kind of invented this new remedy of a suspended declaration of invalidity, which in some ways can be seen as an act of judicial activism, because if you read Section 52 of the Charter, it says if it's unconstitutional, it's of no force and effect. But the Supreme Court, in some of the earlier cases, recognized that they had a responsibility to deal with what happens during the interim. Because that's a not insignificant, right? I mean, for a court to say to someone, you win, but there's no remedy for a year, that's a significant innovation, and even some would say a departure from the traditional judicial role. And so that's why I think it does have to be a two-track system, and that when there is a suspension of invalidity, my view, as in the Manitoba language reference, is the court retains jurisdiction. And so either the court should provide some guidelines about what happens during the period of suspension, which is one thing that we may or may not see tomorrow from the Supreme Court, or the court remains open for individuals during that period to seek an individual remedy. So those are things I would look for in tomorrow's judgment. I don't think there'll be an immediate declaration of invalidity. I've certainly been wrong before. How long will it be? Is it the appropriate time? I think we can have a debate, and I think that parliamentarians have a role to play in that kind of debate. I think 6 months, 4 months just doesn't make sense with the little that I know about your institution. But I do think, and I'm worried that tomorrow the Supreme Court may not address what happens during the interim because both of those cases were moot. And I also worry that the Supreme Court may not address that because of this tendency to say, well, we shouldn't retain jurisdiction because that's a kind of innovative thing that we shouldn't do. And I go back to the Blackstone quote where, in bankruptcy cases and family law cases, courts always retain jurisdiction. It's not the end of the world if they do that in a constitutional case.
We have time for one more question.
Good morning. My name is Jan Campagnolo. I'm a doctoral student at the University of Toronto. My question is the following. What would you say are the limits to the remedial powers of the courts? At what point do we get into improper judicial activism?
Thanks, Jan. That's a tough question, which is only fair because you're my student and I ask you tough questions. I do think that there is a danger of courts prescribing, right? And this is why I think that the minority in Doucet Boudreau really has an unrealistic view. I mean, I don't think that with our government, with our history, even strained as it may be in more recent times of compliance with court decisions, I don't think courts should need to try to enforce things through contempt. So I don't think that courts should get into the weeds. I also, frankly, with the California prison case, I do have some reservations because as polycentric as the issues of healthcare are in prison, I worry that the court has taken on even too much with prison reduction. And I also worry that the focus will be less on what is happening to Californian prisoners who are both needlessly dying and needlessly killing themselves, that the focus will be diverted from that to, can we reduce prison population without endangering public safety? I mean, that to me is, frankly, I think a public policy issue where courts are a bit vulnerable. So my advice for courts would be, focus on the individual. Publicize, and publicize, I don't mean in a political way, but in your judgment, based upon the evidence, tell us what is happening to the individual, award the individual remedies, even at the risk of queue jumping, and then, but not just individual remedies, right? Because litigation is so expensive that the court needs to look at the broader institutional and systemic context that determines the violation. So the heart of the court's expertise is the individual remedy, and then when it comes to the systemic response, I think courts should assume that there is legislative and executive goodwill and competence. If, however, there turns out not to be, I think the courts have no alternative but to try as best they can to provide a remedy. And even if that remedy is ineffective, I think the very act of a judge saying, I've heard repeated evidence, the government is simply not willing to respond to this violation and to this decision, I think a judge needs to, as an independent and impartial person, write that out fearlessly. And if we as a society don't do anything about it, well, we're going to have the democracy that we deserve. Thank you very much.
Thank you very much. I have to say that's your ending was as invigorating and refreshing as your presentation, and also the generosity of engaging with us as an audience. Thank you so much, Kent. We have a little token of our appreciation, which is actually a photo of, or a painting of Ottawa in the winter. So you remember this day for many reasons, but one of them is the weather as well. So thank you very much. Thanks again. I just want to point out that Kent Roach is here today with us through the kind sponsorship and partnership of the Pierre Elliott Trudeau Foundation. We want to thank you again, Maurice Rosenberg, for helping us to bring Kent to Ottawa, and we're grateful for your support in bringing key influential scholars such as Kent to the Hill and to the eyes and ears of the people who are engaged in the policy-making process. Merci encore au CRSH pour leur soutien précieux tout le long de cette série. Merci encore. Et merci également à James Rajot, notre député parrain, notre député préféré, on devrait dire, de la série de causeries Voir Grand. Et c'est grâce à Monsieur Rajot que ces événements peuvent se tenir ici dans ce magnifique restaurant du Parlement. I want to thank you all of you again for joining us today. I want you to know that Kent said everything on the record, meaning that this is not a closed group, and that video of his presentation will also be available shortly on the Federation website, so you can go back and see exactly what he said, or, as I'm going to do, project it to my students as well. The next big thinking lecture in the series will be on March 26th, and this is something that les abonnés, the subscribers to our series know. We're partnering again with the Group for Science and Engineering, and so instead of the breakfast on the Hill, we call it bacon and eggheads. We wanted to call it brains for breakfast, but that seemed a bit bad. So our next speaker will be a dual act. Daniel Scott, the University Research Chair in Global Change and Tourism, and the University from the University of Waterloo, and Ronald Stewart, professor in the Department of Environment and Geography from the University of Manitoba. we'll be have what we do in these kinds of sessions is that we have two speakers and they are moderated by a distinguished Canadian journalist. So that should be, again, fodder and food for thought. Thank you again for being here today. And we want to remind you that beyond what we do here on the Hill, our big thinking events also take place across Canada, and most importantly at our annual Congress of the Humanities and Social Sciences, which is in its 84th year. I'd like to remind you that it's at the University of Ottawa this spring, the first week of June, and you want to make sure you mark your calendars for that really important event for those of us in the social sciences and humanities, but also because of the important kind of speakers that we bring who are of interest to all of the policymaking community, and you can actually see the University of Ottawa from here, so there's no excuse to not try and come and engage with us during that week. Merci beaucoup et bonne journée à tous. Alors, allez dans le grand froid de cette magnifique journée d'hiver canadien. Au revoir.